This is Law Bites, a podcast with Michael Geist. Welcome to the year-end Law Bites podcast. I'm Michael Geist, and this episode offers the chance to look back at 2024. Let me start once again by thanking Gerardo Lebrun-Laboy, who continues to provide exceptional production assistance alongside the incredible array of guests that joined me on the podcast over the past year. This is the 34th new episode this year. I started with Senator Julie Meville-Deschênes in a lively episode debating her Bill S-210, and the podcast series continued with a great range of guests. Scott Jolliffe looked back at the CCH copyright decision 20 years later. Will Page unpacked the economics behind music streaming. Vivek Krishnamurthy, Richard Moon, and Boris Batensky provided what amounted to a three-part series on the Online Harms Act. And there were international episodes as well. We looked at the EU AI Act, Brazil's Twitter ban, and the U.S. move to force divestiture of TikTok, among others. I'm grateful to all for taking the time to share their perspectives and knowledge on an equally wide range of issues. We touched on internet regulation, privacy, copyright, AI, freedom of expression, internet services, the digital services tax, digital trade, and more. For this final episode of the year, I'd like to take a quick look back at some of the more notable developments. Legislation was, in some respects this year, less of the show, as literally nothing moved after the summer break. All the bills alongside the House of Commons are seemingly stuck, and given where we're at in the parliamentary calendar and the likelihood of an election in 2025, those that haven't passed are in some doubt. The marquee bill of the year was clearly Bill C-63, the Online Harms Act. It was introduced back in February and proved immediately controversial. Now, in certain respects, that isn't particularly surprising. The government, and certainly those following digital policy, knew that amongst the trio of bills, the Online Streaming Act, the Online News Act, and then the Online Harms Act, it was the Online Harms Act that was invariably going to be the most controversial. But it didn't take long, in my case, literally 2 days, for calls on the government to separate out the bill. As we discussed regularly on this podcast, there are 4 elements to the bill, but really 2 separate bills welded into one. On the one side, there is the Online Harms Act that focuses on the role and responsibility of internet platforms in dealing with 7 identified online harms, as well as a smaller section of the bill that updates mandatory reporting in cases of child pornography to expand it beyond traditional telecom providers to include some of the internet services. Now, that part of the bill certainly has its critics, but I also think it's fair to say that many look at the foundation of the legislation, recognize that it's largely a product of pretty extensive consultations and the government's willingness to go back to the drawing board when it came to regulating online harms, and leaving a sense that this was something people could work with. I think there are concerns around some of the enforcement mechanisms that are established within the bill. There are questions about the 7 harms that have been identified, whether there should be more or in some instances less. But nevertheless, it's a workable framework. The part that really led to this bill becoming as controversial as it has and effectively stalling it in the way that it is stalled is what really amounts to a separate bill. And a separate bill within Bill C-63 that deals with 2 other elements. There are reforms to the criminal code, and there are the inclusion of a new provision dealing with the Human Rights Commission. Now, I think both of those have proven far more controversial, and to the extent to which there are those that look at this bill and talk about censorship or have real concerns around freedom of expression, much of that lies in those elements. As I mentioned, we had both Professor Richard Moon and Boris Batensky, a leading criminal law lawyer, walk through both of those elements, and both found some significant concerns. I think the net effect of all of this, of having a bill that brought elements that people were okay with, although, as I say, there are still some critics, and elements that seemed like a non-starter to many, was this bill really became bogged down very quickly. So it was introduced in February. Throughout the spring, there was some debate about the legislation, but it didn't really advance much in the House of Commons. And with the delays that we've seen in the House throughout the fall, it really didn't go anywhere at all. Now, in recent weeks, we've seen a few developments. First, we saw the Conservatives, or at least Conservative MP Michelle Rempel Garner, introduce her own version of an online harms bill. It's a slimmed down version focused primarily on protecting kids. That was introduced as a private member's bill, but as some of the debate began to unfold, it became pretty clear that the Conservatives had adopted it as their alternative to the government's proposal. The government itself, having recognized that this bill was quite literally not going anywhere, it's still stuck in the same place that it was back in the spring, finally agreed to separate out the bill. And so Justice Minister Arif Virani recently announced that the government would create two tracks, a track for the elements of the Online Harms Act, plus that child pornography reporting piece, and then a separate track, which I must admit feels like a bit of a road to nowhere. It's really, I think, elements of the bill that are going to die, that were the Criminal Code and the Human Rights Act provisions. Government tried to kickstart things a little bit by having the Justice Committee commence what is being referred to as a pre-study. The bill hasn't been referred to the committee yet, and so the committee has begun to hold some hearings on the bill in anticipation that it will be ultimately referred over to the committee. Government also sought unanimous consent in the House of Commons to refer the bill onto committee, but it was unable to get that. The Conservatives in particular have been very critical of the legislation. They argue that it isn't really two bills in one, or at least their division of two bills in one is a bit different. They say the Online Harms Act is sufficiently objectionable that they group it together with the Criminal Code provisions and the Human Rights Act provisions, and really are only willing to support the child pornography reporting provisions alongside their own specific measures that they've identified in this private member's bill. So it didn't get unanimous consent, and so the bill is still in the House. It's certainly possible when we turn into 2025 that the delays that we've seen in the House of Commons will come to an end, and the bill will go to committee. But given the need for pretty extensive hearings, the prospect that even if it passes in the House, the bill then will go on to the Senate, the clock is ticking, and the likelihood that this becomes law is certainly far less, I think, than it was when the bill was first introduced in February of this year. Now, beyond Bill C-63, there were several other bills that didn't really go very far or had minimal progression. I mentioned off the top that the very first episode of this year's podcast involved the debate with Senator Mavil Deschênes on Bill S-210. That is the bill that is designed to limit underage access to pornography, envisions age verification requirements, and has raised a pretty wide range of concerns about the scope or breadth of the legislation, as well as the privacy implications of requiring age verification technologies. Now, that bill was referred to committee in the House, having already passed in the Senate, so it only needs House approval at this stage. But there were no real hearings. There was a filibuster that took place at the committee that was charged with conducting the hearings, and at the end of the day, there was just a single day of hearings, and the bill was voted out of committee without any changes at all, without any real debate, without the kind of review that one might have otherwise expected. And that really left just one core approval left. The bill sent back to the House of Commons, and the House then would vote up or down on this legislation. And the prospect that it could become law, I think, was very real. Given the delays, that hasn't happened yet, and we don't know when or if it will happen. I think it's fair to say we also don't know where all the parties stand on it. The government is opposed to it, so Liberal MPs, for the most part, can be expected to vote against it. There's a bit of uncertainty as to where the other parties stand. It's been the Conservatives that have been most supportive of this legislation, but whether or not at the end of the day they're willing to vote for age verification technologies, as opposed to saying what they'd really like to see is an emphasis on their proposal when it comes to online harms, remains to be seen. And as I say, we will see whether or not the bill actually makes it that far. There is also Bill C-27. That's the Privacy Reform and AI Regulation Bill, another example of a bill that brings together really two bills in one, and has similarly faced criticism for the approach, with, I think, many of the view that had the government separated that bill out, the privacy elements of the bill might have proceeded much quicker, and the AI elements would have been subject to, I think, greater debate and discussion. But yet the government moved ahead with a single bill, and this bill has been at committee for what is referred to as clause by clause review as they go through the bill on a clause by clause basis for many, many months. They've done much of the clause by clause on the privacy side of the bill. They have not done clause by clause on the AI portion. And so those that would have expected the committee to have certainly concluded clause by clause this fall will be been disappointed. That didn't happen. And so this bill is also, I think, running into the prospect of running out of time. Now, it's certainly possible that the committee will pick up and try to move ahead and come up with a final version of the bill to report back to the House. But of course, then we'd have to see whether or not the bill has support. And then that bill will itself also go to the Senate for its own set of hearings and review. Given the timelines, the prospect of privacy reform and AI regulation, at least as contained in Bill C-27, is in some doubt. Now, one bill that did pass the House and has passed the Senate, but has actually been referred back to the House, is Bill C-26, which is a telecom bill that involves some security-related issues. Kate Robertson joined the podcast earlier this year to talk about some of the privacy concerns associated with the bill. Now, in this instance, there were Senate hearings on the bill after it passed in the House, but as part of those hearings, they came to the realization that amendments were needed because the way it was structured, due to some drafting errors and some changes that were made, held the prospect of nullifying half the bill. Honestly, don't ask how that has happened, but it has. So the bill's been amended, and because it's now a Senate amendment to the bill, it has gone back to the House of Commons for approval. That hasn't been taken up yet. My expectation is that it won't be taken up until into 2025. But once that happens, these elements are pretty non-controversial, at least for those that have approved of this bill in the past. And I think it's reasonable to expect that sometime next year, this is one example of a bill that actually will pass. There were some other bills that did pass as well. It's worth highlighting at least a couple. First, on the copyright side, the Copyright Act's been amended by two private members' bills, Bill C-244 and C-294, which create new exceptions for the technological protection measures aspects of Canada's copyright law. I also focused on those bills in a prior Law Bites podcast episode. Now, the exceptions focused on two aspects of circumvention and technological protection measures. First has to do with interoperability. That's C-294. And the second is a right to repair, diagnose, maintain, or repair certain type of products. That's in Bill C-244. Both of those are now law. Now, it's true the government could have, or successive governments could have established these kinds of exceptions by way of regulation. In fact, we've had governments often say that that's the structure that would allow for the addition of new exceptions to the technological protection measures provisions. Governments never seem to want to get around to it. And so these private members' bills have essentially done the work that government should have been doing all along, I think, when it comes to some of these issues. They are now part of the Copyright Act. There is also at least one AI bill that did pass at the provincial level. That's in Ontario. That's Bill 194, which regulates some pretty significant digital issues, touches on cybersecurity, AI, and digital information of kids. It is subject to future rulemaking, though, with regulations that will be set by the government to oversee some of its own public institutions. And it's worth noting that at least the Ontario Privacy Commissioner has been quite critical of the legislation, pointing to what it views as a lack of transparency, explicit independent oversight, and concerns around the democratic processes around the bill itself. Now, lastly, there's Bills C-59 and C-69, which we don't usually think of in a digital context, but those are the two bills that implemented tax measures coming out of the 2023 fall economic statement and the 2023 and 2024 federal budgets. Why reference all of this? Because earlier this year, particularly in July, the digital services tax in Canada was enacted, as there was an order in council towards the end of June ensuring that it was now going to take effect. The DST is an annual 3% tax on digital services revenue that is considered attributable to Canada. The government is taking a retroactive approach, so it actually dates back to digital revenues that come from 2022 and 2023. It will only begin to be payable next year. In many respects, this is now the most controversial, from at least a trade perspective, digital issue between Canada and the United States. We had a chance to talk about this on an earlier episode with Meredith Lilly, who broke down the DST and questions as to whether or not some of the approaches we've seen the government take may violate some of its trade obligations. But with the election of Donald Trump, quite clearly there are a lot of trade tensions potentially in the offing between the two countries. And the DST has been a hot button issue for a number of years. We are talking about potentially billions of dollars. It is strongly opposed by certainly the tech companies who would be captured by this, many arguing that Canada ought to be trying to find a way to work within an international framework that's been designed around the DST. But at the same time, you've got a Canadian government that quite clearly looks at the potential revenues coming out of a DST and is very reluctant to give those up. We'll have to see how this particular issue unfolds, but the U.S. has already begun processes that could lead to a trade challenge, Canada insisting it's going to continue with its DST, and that could, at a minimum, spark retaliatory measures that come out of the United States, although, of course, the Trump administration is already talking about significant tariffs on Canadian products. How all of this will shake out remains to be seen, but in some ways, this is one of the core issues looking ahead to 2025 on the digital policy front. So that's the legislative activity, primarily at the federal level and a little bit at the provincial level over the past year. So what else took place? Well, there were those other two bills, the streaming bill and the online news bill, C11 and C18. And with both of those passed in the prior year, this was the year that we moved forward with some of the implementation aspects of that legislation. In the case of C11, that's largely meant activity at the CRTC and its decisions, which included establishing a new mandated base contribution for many of the streaming services and platforms that operate in Canada, so long as they meet a minimum threshold, has itself sparked both appeals at challenges within the courts, as well as a bit of a public debate and lobbying campaign around these payments, with the payments being referred to as a streaming tax. It's likely, in fact, in some instances, it already has resulted in increased consumer costs, or at least has been attributed, or at least the existence of these payments has been cited as one of the reasons that we see some of the consumer costs going up. CRTC has also launched a very consequential hearing that will take a look at the definition of Canadian content, or CanCon. That will play out over much of the year. They used this past year to conduct essentially some private workshops and private meetings on some of these issues. They've come back with a bit of a report on some of the things that they heard, and now have opened up that consultation more broadly to the public. And it is certainly possible, as they work through that over the course of the year, that we could see a new series of definitions in terms of technically what Canadian content means, which will have some pretty big impacts in terms of different kinds of services or activities, professions that work in, let's say, the film and television production sector, and what counts or what doesn't count for the purposes of counting as CanCon. It's proven somewhat controversial as well on the music side. For example, we've seen Bryan Adams express real concerns about where the law is right now and potentially where some of the changes may be going. There's also Bill C18, the online news bill. We ended last year with a late deal between the government and Google, having already recognized that Facebook or Meta wasn't about to pay anything. And in fact, they'd been blocking news links a year ago for a number of months at that time. The government was desperate to get some sort of deal with Google. I think it's fair to say the media entities were as well. And so Google agreed to pay $100 million a year in return for an exemption from having to negotiate directly with any of the various players and essentially being exempt from any further monetary requirements. Some of the other requirements in the bill still apply, but the specific elements of payments are basically covered by this $100 million payment. What that meant was, over the past year, we saw efforts to try to operationalize this aspect of the revenues. In the case of Google, they opened the door to having negotiations with a new collective to administer the distribution of this money. And there were competing collectives, another issue that was addressed over the course of the year on my podcast. And in this instance, the collective that was ultimately chosen by Google was a collection of independent media outlets, which was a bit of a surprise, or at least a bit of a surprise to some of the more established, larger players who I think, by and large, assumed that they would be the winners and would run the collective that would be involved in the distribution of the money. There was a lot of opposition from those established entities regarding this new collective, but ultimately the CRTC granted its approval, established some of the frameworks, and the expectation is that if certainly potentially by the end of this year, so within the next few days, or very soon thereafter, that $100 million will be allocated and distributed. Now, beyond the Google money, there is, of course, still Meta with Facebook and Instagram in particular. They are still blocking news links, and so now have been doing so for about a year and a half. The government's not happy with it. Some media companies aren't happy with it. And so they've been urging the CRTC to look into ways that users may be seeking to circumvent some of that news blocking through screenshots and other kinds of mechanisms. Meta's been reluctant to disclose some of that information to the CRTC, but very recently, as the CRTC continued to push, it appears they have caved and will provide some of that information. We'll see in 2025 as to whether or not the CRTC says that user screenshots are somehow something that Meta has to compensate for, or that would bring them into the scope of this legislation. And if so, whether or not they begin to try to block that kind of content as well. I think it's fair to say that is not what the legislation envisioned. There was not discussion around screenshots when this legislation was being debated in the House of Commons. And it's pretty far removed from a world of saying mandated payments for links to saying you've got to pay when your users post screenshots to underlying materials. I guess lastly, and just in the last few days as I record this, there have been developments in Australia that I think in many respects highlight that this particular model, this Australian model of mandated negotiation based largely on the notion of linking to content, is generally dead. You know, the Canadian system, it's really is dead, and the Meta is not paying. And Google agreed to pay a lump sum not to enter into the negotiations directly with these various players. And in fact, there's a provision in there that explicitly says this isn't payment for links. In the case of Australia, it was often cited as the jurisdiction where this was successful. But what we've now found is that as those initial deals between Google and Meta are coming due, Meta at a minimum has said that their business model has changed. They are not willing to pay for links in Australia, much like they're not willing to pay for links or news content in Canada. And Australia's response now is to say that if you don't pay, we're going to tax you specifically on this issue. And so we're heading to a world where this notion of paying for links is by and large over. Instead, it's taxation, it's direct government intervention and negotiation with the platforms. Notably in Australia, they've moved beyond just Meta and Google. Now they include TikTok as well. So we'll see how things play out in Australia. It's pretty clear that media outlets are still anxious to find ways to generate revenue. Governments are still pretty anxious to find ways to try to support that. But the model of a mandated negotiation based largely on the so-called value for linking, that particular model seems to be coming to an end. So that's the implementation of those two bills. Let's spend a few minutes talking about what took place in the courts, as well as some of the regulatory issues. And there's a fair amount to talk about here as well. You know, speaking of a desire for payment when it comes to the media companies, we had a lawsuit that was launched just in the last few weeks, addressed on last week's podcast with Robert Diab, where some of the major Canadian media outlets are suing OpenAI for the inclusion of their content within the large language models, essentially for the scraping of their content. That lawsuit largely viewed as an attempt by media companies to find another source of revenue, in this case, revenues through some sort of license from AI companies. It's not the only AI lawsuit that we've seen in Canada. We've seen some others as well, or at least one other notable one by Canly, which an entity that publishes legal information in cooperation with courts and tribunals from across the country. They have sued an AI company, Caseway AI, based out in BC, for its act of scraping those decisions. Both of those cases will be interesting to follow, certainly in 2025, as they'll go to some of the really thorny questions around the copyright implications of scraping content. What does it mean to say you don't want your content scraped, the application of fair dealing, and the like. Now, in addition to the AI lawsuits that will play out over the course of the coming year, there are several decisions that were concluded that are worth highlighting. Actually, there were episodes on all of them over the past year on this podcast. There was the BlackLock's copyright case, a case that involved questions of fair dealing and anti-circumvention rules. BlackLock's being an Ottawa-based media outlet that has been suing a number of different government departments where some of their content has been shared within the department. It's an interesting case that has now been appealed, which raises questions as to whether or not passwords are circumvention, the terms of use that are used on the website, which the court found to be inadequate based on, I guess, what the company expected, as well as the application of fair dealing in the sharing of some of this kind of information. You can learn more about that decision in an earlier podcast with James Plotkin and David Fewer, who were interveners in that particular case. There was also a notable privacy case involving Meta. We also covered this case with David Fraser earlier this year, one of the very first and earliest privacy controversies involving Facebook and questions about Cambridge Analytica. That case is still ongoing, believe it or not, many, many years later, starting with a finding from the Privacy Commissioner's office, actually joint findings between the federal and BC Privacy Commissioner. The Facebook or Meta challenged that finding at the federal court, was successful in doing so. They then went to the Court of Appeal. The Privacy Commissioner appealed that at the Court of Appeal and was successful with that appeal. And Facebook is now looking to take that case to the Supreme Court. So we'll see. There is still at least one more shoe to drop with respect to that decision. There was also the Bykovitz decision, which was the most important Supreme Court privacy decision this past year. There was here too an earlier episode with Vibert Jack that focused from the BCCLA, which focused on this particular decision. It's a decision that focuses on the extension of reasonable expectation of privacy to IP addresses. Supreme Court's earlier decision in the Spencer case, going back to 2014, affirmed a reasonable expectation of privacy in basic subscriber information. In Bykovitz, this gets extended to a reasonable expectation of privacy to IP addresses. And you can certainly learn more on that particular decision in one of the earlier Law Bytes podcast episodes. Now, finally, there are a series of other activities largely based at the regulatory level that are worth highlighting. First, there is the curious government decision to ban TikTok's corporate offices in Canada. Curious because we've seen some countries that have raised concerns about the privacy implications or security implications of TikTok, given perceived connections to the Chinese government. In fact, the federal government has banned use of the app on government devices. But rather than banning the app in Canada, the government's gone out of its way to say the app is not banned. It has instead decided to kick the company out of Canada, or at least said that it wants the corporate offices located in Toronto and Vancouver out. As I say, it's a somewhat curious decision because it doesn't really address the privacy related or security related concerns at all. In fact, the Privacy Commissioner recently told a House of Commons committee that the ability to enforce laws is typically easier if you've got a physical presence of the organization or company in the country. And so this will make enforcing Canadian law more difficult. It also, in some ways, undermines some of the kinds of contributions the government had been pushing for from platforms like TikTok. So they've been big donors and supporters of different cultural initiatives. And if they're kicked out of the country, they can be expected to stop those. Now, that decision has been challenged by TikTok in the courts, and we'll see in 2025 how it plays out. Also, late in the year, we saw the Competition Bureau file a lawsuit for anti-competitive behavior against Google. This involves specifically Google's ad stack or some of its power on the digital ad side. It largely mirrors the cases that we've seen, especially in the United States. But Canada is now following suit. And so we will see that case, I think, play out in the coming year as well. There's been lots happening at the CRTC beyond what I already discussed in terms of CanCon and C11 and C18, particularly around things like wireless and internet-based services. ongoing concerns about the state of competition, and real concerns around consumer-related issues, the contracts and sort of some of the elements that we see in those contracts, pricing-related issues. CRTC is holding a whole series of different hearings on some of these issues, some of them driven by the prior government decisions found in the budget to try to greater transparency and support for consumers. See how some of it plays out, but it's pretty clear that the CRTC is trying on this issue to position itself as consumer friendly. Some of its issues on the competition side, though, has certainly seemingly left just about everybody unhappy. An issue, again, to look forward to in 2025. And if you want to learn more, I had a recent episode with my colleague Marina Pavlovich that focused specifically on the consumer aspects of CRTC engagement when it comes to some of these issues. And finally, with respect to AI, just a bit more on point, it's popped up already a number of times, come up in the context of Bill C-27, come up in terms of the lawsuits that I referenced. But in addition to that, the government also did hold a consultation this past year when it came to AI and copyright, focused specifically on generative AI. We haven't seen the so-called What We Heard report that we can be expected for the government to release, but those various submissions, including one that I submitted, are available. And I suppose somewhat unsurprisingly, the usual suspects say the usual things. So we get certainly some who argue that there is a need for real flexibility here, a text and data mining exception, that the innovation associated with AI is important to support. Others who want to see new licensing brought to bear in this space as well. And you can see the government really challenged in how to deal with some of these issues. It's announced significant investments in support of the AI sector with data centers and other kinds of elements where it wants to really build up leadership when it comes to AI. But that's going to be challenged if you take a look at the United States, which under a new Trump administration is likely to relax AI regulations or really not move ahead with anything significantly restrictive at all. And so for those looking to set up shop or invest significantly in AI, whether they would choose a jurisdiction with far more regulations as opposed to one that has a lighter touch, will present, I think, a real challenge for those jurisdictions that want to move strongly ahead with AI. We'll see if people are able to find a bit of a middle ground in trying to find ways to deal with some of the concerns that have arisen in the context of these AI services and at the same time create a competitive environment for AI. So that's my look back at 2024, a really eventful year, even if not in the House of Commons, definitely elsewhere. And it's pretty clear that there's quite a number of these issues that will continue to unfold as we head into 2025. So I'd like to wish all listeners a happy holidays and look forward to returning with some new episodes sometime early next year. That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. That's LAWBYTES @POBox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @MGeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening and see you next time.